Street.
Yes. Next.
This is a tenant at a shop room at Park Street. They run a boutique store there. Now, what has happened during the last month for the few days, the landlord, the defendant, has started breaking down the two shop rooms adjacent to the plaintiff shop room, which are under their occupation. And what they are doing, my lord, they are completely breaking down the entire shop rooms. But may I suggest, say, my lord, they have already served us an eviction notice. On the garb of an eviction notice, they are trying to evict us during the puja vacation. My lord will see, kindly take. We have filed 144. We have taken all steps. We have filed police complaints. My lord will kindly come to page 105, and I'll show the pictures then and now. My lord will understand what they are doing and how they are going ahead. 105 of volume 1, my lord.
Yes.
There are, my lord will find people are there standing and breaking down the roofs.
Roofs of what?
The adjacent, my lord, this Tenancy is my shop. My lord will find people are breaking down. My lord, they have not broken down.
Shop? What is your shop? Where is
Tenancy
your shop?
at Park Street, just next to, my lord.
Where is your shop? Where is the picture?
My Tenancy, that is written TAN.
Page 105.
Page 105, my lord.
Page 105.
My lord will see one man sitting on top of my shop. Annexure O. And my lord will find the next pictures. My lord kindly takes 107. They are continuously breaking those shops. And my lord, as on yesterday, my lord, this has happened.
What has happened?
They have completely broken down the next shops, damaging my wall. During the pujas, they have continued the breaking down. And now there is vacation.
Tenancy.
The next shop is completely raised to the ground. Shops on my right, shops on my left are completely raised to the ground. We are tenants in 2006. We are statutory tenant under the Premises Tenancy Act.
This is not your wall, sir. This is not your wall.
No, my lord, kindly see the next wall. Well, what they will do is, now during the vacation, if they break down one part, my wall will collapse. The structural stability will go, my lord.
They have already broken their the
one side, and they are broken. As on date, they are breaking the walls.
But I do not find any appeal.
As on date, they are breaking, my lord. As on date.
I'm not finding any urgency in this matter.
Well, kindly seize my prayer, my lord. Kindly seize my prayer, my lord.
Your prayer maybe, sir. You are showing the picture. Your shop is intact now.
But they may break down, my lord. I do not know what will happen. My lord, kindly prayer, my lord.
They could have broken all the your wall, but they didn't touch your wall.
But from the behind they have broken, my lord.
Where?
It's a common wall, my lord.
What is the picture, sir? Your wall has been damaged. Where is the picture?
My lord, kindly see this, my lord. From the back side, my lord.
Did you?
Kindly see on the top and corner.
Which wall is your backside wall?
Kindly see that broken part portion.
Broken portion, your backside?
Yes.
This is vacant. This?
Yes.
This
no,
one?
but corner on the corner, not top. On the corner top, my lord.
This one?
Yes.
But
one big hammer, this wall will collapse, my lord. Shop's goods worth 1 crore is there, my lord. Water is seeping in. But simple prayer, my lord, kindly takes page 19. Kindly takes page 19.
It is.
I am seeking prayer A and B, my lord. What will the prejudice? My lord will keep it just after vacation. On the reopening day or one day after, my lord, kindly protect me during this puja vacation, my lord. I have nowhere to go. And Diwali sale is coming. A very innocuous prayer, my lord, it will not affect them. It's a very innocuous prayer not to demolish the walls and roof of my suit premises and not to disturb our peaceful possession and occupation. Page 19.
I've seen.
A very innocuous prayer. My lord keeps it on the returnable date. 4th or 5th, my lord keeps it. We will serve and come back, but my lord kindly protect us during the vacation.
This suit has been filed. This is by the plaintiff's petitioner. By the plaintiff's petitioner, claiming themselves to be the tenant in respect of the premises, West Bengal premises, and in respect of premises, in respect of shop room number SH capital /B capital B 9/93 at 93 Park Street Police Station, Park Street, Kolkata 16. Measuring about 1,140 square feet at a monthly rental of rupees 3,600, payable according to English calendar. Suit has been filed with a prayer for an order of promulgation. Filed. What is the prayer of the suit?
My suit is at page, my lord, 142, second volume.
The second volume ta kothay? This is
Volume 2 to the
GA1, GA1 CS 208.
The prayers of the suit are also set out at page 14. Page 14 of the application, my lord. Paragraph 33, we have set out the prayers.
Paragraph 33.
Paragraph 33.
It has been filed with a prayer for declaration of tenancy in respect to declaration in favor of the plaintiffs with respect to tenancy of the premises mentioned herein above, and so that the defendant cannot evict the plaintiffs without due process of law, along with consequential reliefs. Full stop. The instant application has been you should notice what is correct. Should notice upon the defendants. Returnable copy খুলছে 4th returnable on 4th, the all ঠিক আছে. Next para, counsel appearing on behalf of the petition that the defendant, landlord, is trying to disposes the plaintiffs without due process of law.
না আপলোড না করলে কি করা হ্যাঁ 24 hours
Damaging the
we have till tomorrow
wall of the Roof. Your prayer is roof. What is your prayer?
The prayer is at page 19.
Roof, one and walls. Roof and walls. Yellow? Roof and wall of the subject shop. In next para, in support of his contention, it is submitted that some photographs have been shown to this court. Full stop. Given facts and circumstances, given facts and circumstances, the prayer for ad interim injunction stands allowed, directing, restraining the respondent, restraining the respondent from demolishing the roof and walls of the suit shop. This shop. Till the returnable debt till the disposal of this application. Cheque. All until further order, whichever is earlier. Requisites of the area. Requisites तो आगे ही बोला है. Let the matter appear on fourth. So, roof and wall, they are restrained from demolishing your roof and walls only.
And my lord,
Till the
kindly
next date.
serve the copy today because I have to serve within 24 hours.
Yes, it will
You
be.
have to serve. Oblige, my lord.
Both sides will act on the. No, not today. It is. Not today. Not today. Not today. Chalo. Application.
Oblige, my lord.
Lord, before my Lord takes up the appellate side, Madam Lord, one kind indulgence.
Quarter.
Lord, one kind indulgence, Lord.
No, sir.
Very urgent, Lord. Just seeking leave to file it on 18th, Lord. Seeking to move it.
18th.
Lord, the only urgency is, Lord, that the petitioners are dialysis patients, Lord. The bank accounts have been debit freeze, Lord. Lord, I'm just seeking 18th. Lord, I'm just seeking leave to file it on 18th, Lord. Lord, I'm just seeking leave to file it today, Lord, and to move it on 18th, Lord. Your Lordship, my kindly, Lord, grants this indulgence, Lord. Lord, very urgent.
18th.
Extremely grateful, Lord.
My also very urgent. PRMSB.
In item number 1, I am for the petitioner, my lord. Here, petitioner is.
Last order passed by my lord. Letter part.
Letter part.
Letter part of the last order.
Only one part, Supplementary list. 7th October. Directed to
Copy of the application
along with annexure thereto upon the opposite party file evidence of service on the adjourned date. What is the date? Where is the date? Adjourned date means on prayer for petitioner, liberty is granted to move the application before the annual vacation. But subject to compliance of the direction.
Yes, nothing. No intimation has been given. As a mark of respect to this institution, we have come with the case diary.
But my lord, they have not complied with the
Uh,
order.
My lord, kindly, may I humbly submit? We does not know how this petition came today, because we does not paid for any further leave.
Sir, please,
to-
please try to
Yes, my lord.
make
On the
yourself
last
understand.
occasion, the
What
state
was
was,
the order?
yes, my lord.
When leave was granted, what was the order?
My lord, it was liberty only. We does not go with the liberty. We does not mention to,
That you on your prayer, liberty was granted on prayer of the petitioner. Liberty is granted to move the application before the honorable vacation bench. What was the condition? You were directed to serve the copy of the application along with annexure thereto upon the opposite party and file affidavit of service on the returnable date. What is the service?
my lord, further,
18. Chalo. Comply this order, sir.
But-
Not today. Next. Comply this order. first.
Let it to place before the regular bench then.
but my lord, they have come with the
But they
case.
have-
that-
18, come on 18, serve it. No
No,
problem.
they are telling that
Comply the order.
they have not mentioned for listing the matter before the vacation bench.
Then
If they have not mentioned, let it be placed before the regular bench.
it is written on prayer. It is written on prayer. That's why I'm saying that on your prayer
Great.
it was fixed today. So you have to comply the order. You have to serve the copy of the application.
Yeah, that's right.
Come on 18th. Come on 18th. In the meantime, serve copy. Comply the order of the court. Next, what?
Okay, my lord, we will comply.
আজকে করতে হবে? My lord, may I say one thing? We are ready with the case diary. Your lordship may hear it out. We are ready with the case diary.
Sir, I have already dated. Not possible. Now I am.
It's we are ready with the case diary. my lord.
Sierra 1874. Who is?
18 তারিখে
Yes. Where is the urgency? Is there any urgency, sir? Where is the urgency?
My lord, in this matter, all on a sudden, I find this matter has appeared in this list, my lord. I never mentioned for vacation. Before that, I mentioned that there is urgency because some warrant is running against my client. Matter was heard by the Honorable Mr. Justice, Mrs. Justice Subrag Ghosh. And thereafter, I find that matter has appeared here after considering the urgency about the warrant of arrest. So far, my knowledge goes. And so far, your lordship will find the fact remains there were two orders. One order passed by 6th additional district judge for rupees 2,500 per month. Another was passed by the 4th JM for rupees 3,000 per month. My lord, there is clearly mentioned adjust. But this lady, the opposite
Who is appearing on
respondent,
behalf of the opposite party.
my lord, opposite party enjoying both the money. For last 10 to 11 years, there he is enjoying both the money. 6,000, 630 years, 2,500 and third year, 3,000, third gem, 3,000 rupees. That is 5,500 rupees she is enjoying every month.
Any interim maintenance, this is purely with respect to 125.
Yes, ma'am. One is 125, another is section 24.
125 and 24.
Yes, ma'am.
24, it was granted 3,000.
2,500.
2,500.
And 125, there was initially it was granted 1,200 rupees. Subsequently, criminal appeal was there. There enhanced is
So how much in all, sir?
3,000 from 4th gem
Uh,
and 2,500 from 6th
yes,
ADA.
you are paying the
My lord, I am paying 5,500, but she is entitled only 3,000 rupees.
3,000 rupees.
Yes, my lord, from both the court, she cannot enjoy. Your lordship knows it very well.
Paid. How much is now she is entitled? What
They
is
are
the
claiming,
interest?
my lord, they claiming they swear an affidavit before the Tirthankar Ghosh, Justice Tirthankar Ghosh, that she is entitled to get 5,000, 5 lakh something or 4 lakh something.
Give it.
Calculating 5,500 rupees per month. My lord, actually she is entitled to
Sir,
3,000.
you are only counting the how much was accrued, how much the arrears. You are not actually paying.
No, my lord, no. My lord,
When you will
as
pay,
per the direction of the
how much you
Supreme
have
Court,
paid?
my
How
lord,
much
I am
you have paid?
filing one statement of accounts, where from your lordship will find she is entitled to get only 1,32,000.
Give it to her. Give it to her.
My lord,
Give it to her, 1 lakh.
my lord, that I will pay, but my income is 2,500. I am filing my income tax paper, my lord. I am ready to pay. I am disclosing all.
2,500 per month.
Yes, my lord. That is the because I was agent. We used to work as agent in LIC.
Huh.
LIC has gone. I have already filed application 127 before the trial court. My lord, everything documents are there.
So go to the regular bench. Details hearing is required. Did you
Yes.
file? Madam, আপনি কি ফাইল করেছেন এফিডেভিট যেটা
না এটা নিয়ে এসছি আজকে
My lord,
file
today I am
করতে।
filing.
দিয়েছেন
না এক্ষুনি দিয়ে দিচ্ছি।
কপি দিয়ে দিন।
হ্যাঁ কিন্তু মানে আমার একটুখানি বলার ছিল যে এখানে আমার প্রথম উনি একটা ডিভোর্স কেস ফাইল করেছিলেন 2008 সালে। তো সেটা পরবর্তীকালে নাম্বারিং হয় 2000 মানে 10 সালে উনি আবার মানে ম্যাটসুট কেস নাম্বার 75/2010।
আপনার
সেই-
কোনো উকিল বাবু আছে না?
না আমি ইন পার্সন মানে
আচ্ছা।
রিপ্রেজেন্ট করছি। তো সেখানে মানে আমরা মিস কেস একটা ফাইল করেছিলাম, সেখানে অ্যালাউ হয়েছিল ওনার মানে তখন ওনার পার মান্থ অ্যানুয়াল ইনকাম ছিল মানে পার মান্থ 1,08,000 মতন অ্যানুয়াল ইনকাম ছিল। এই বেসিসে আমাকে 2,500 রুপিস মেনটেনেন্স পেন্ডেন্টিলাইটি অ্যালিমনি।
কি চাকরি করতো?
হ্যাঁ?
আপনার স্বামী কি চাকরি করতো?
মানে উনি এজেন্সি করতেন ইয়েতে
আচ্ছা,
LIC
LIC তে।
এলআইসি।
এবং ওনার অন্যান্য বিজনেসও ছিল, মানি মানে লার্নিং বিজনেস, এবং ওনার ল্যান্ডেড প্রপার্টিও ছিল এবং যার থেকে ওনার আর্নিংও আছে।
নেক্সট নেক্সট।
প্রায় 14 কাঠাস ল্যান্ডেড প্রপার্টি আছে।
হুম।
তো সেই সব দেখেই আমার বিয়ে হয়েছিল। কিন্তু পরবর্তীকালে উনি প্রচন্ড আমাকে টর্চার, এখানে উনি ক্লেম করেছেন যে মানে আমি নাকি ওনার ওপর মিসবিহেভ করেছি এবং মানে কি বলবো মানে খারাপ অ্যালিগেশন দিয়েছে আর কি আমার ওপর। দিয়ে উনি বলছেন যে কিন্তু একটা পুলিশ ইনকোয়ারি রিপোর্ট এখানে সাবমিশন করা আছে যে যেখানে বলা হয়েছে ওনার পাড়ার, কারণ সেই
ডিটেলস হিয়ারিং ইজ
হ্যাঁ
required.
কিন্তু
Come.
My lord, may I submit
Try
one
that.
matter, my lord?
Come.
My lord, may I submit one matter?
Both the landed
My
council.
lord, let a
Yeah, what-
direction be given to
Landed
swear an affidavit that she is not getting any money from pension holder from the railway.
হ্যাঁ সেটা
My
সম্বন্ধে
lord, let
বলতে
a
চাই।
affidavit be filed.
সেটা আমি বলতে চাই।
সেটা বলতে চাই না, let affidavit be filed before High Court.
হ্যাঁ সেটা কারণ আমার বাবা সাউথ ইস্টার্ন রেলওয়ে এমপ্লয়ি ছিলেন,
Pension পাচ্ছে।
উনি মারা
Matter
গেছেন
was not mentioned for fixing it.
এখনো পর্যন্ত প্রায় 4
My
লাখ।
lord, let a direction be given for
the vacation bench. Next. Opposite party appearing in person has filed the affidavit. Affidavit in opposition. What you have filed? আপনি কি
If-
ফাইল করেছেন?
হ্যাঁ এফিডেভিট ইন
Opposition.
হ্যাঁ, হ্যাঁ।
My
Opposition.
lord, I am statement of accounts.
Statement of account.
Yes, my lord.
You have
That
not
was
filed-
direction.
You are not filing any.
এফিডেভিট
I am the petitioner. I have filed.
No. You have not filing any reply.
Again, right now he has not filed, hasn't supplied me copy.
Supply, yes. Supply one copy.
Yes, right now I received this copy.
আচ্ছা আমি একটুখানি লিখে দিই।
Filed one affidavit of service. Liberty is granted to the petitioner to file affidavit in reply. That a part landed counsel appearing on behalf of the petitioner has filed one statement of account.
Under that I filed statement of accounts from the petitioner's side.
Let the matter appear before the regular bench.
My lord, let a direction be given for filing an affidavit with regard to pension matter, my lord. My lord, this is my great submission before your lordship.
Sir,
She is earning a lot of money towards pension from the railway. Her husband used to work in the railway and she is getting the pension.
হাজবেন্ড আমার রেলওয়েতে
My lord, she is denying everything. Let an affidavit be filed.
এলআইসি তে চাকরি করেন,
Madam,
আমার
let an
husband
affidavit
railway তে
be
চাকরি
filed.
করেন না।
Before
কথা।
the regular court. চল।
তো আমার বাবা মারা গেছে।
As your lordship, as your lordship.
Next.
দিন, এটা
ডাকুন.
Item number 3. Lordship, if I may be permitted to,
Huh? Yes?
Lordship, if I may be permitted to
Please.
mention one matter, Lordship.
Item
I
number
was,
3.
ek minute,
Don't
ek-
mention it.
Lordship, I was before court number 8, Lordship.
Not at all.
Kindly, it's very urgent matter, Lordship,
Next,
kindly.
three.
Lordship, I'm appearing for the petitioner, my lord. Lordship, in this matter, An FIR was registered against the petitioners in the year 2007. The charge sheet has been submitted in the year 2009. My lord, the case has been committed for trial in the year 2020. My lord, will kindly come to page 26 once, my lord. Page 26. 26. Order number 14, dated 14th of August 2023.
26.
My lord, may I read, my lord?
Today is fixed for.
Today is fixed for appearance, accused persons, and consideration of charge. All the three accused persons on court bail are present by filing Hajira. Learned PP so-and-so submits that he has not yet received the CD. Lordship, the court notes over here that record reveals that Learned PP in charge entered into appearance on so-and-so, and since then, he has not received the CD of this case. As a result, the matter has remained pending since long. The accused persons are being harassed unnecessarily, my lord. My only prayer before this honorable court, your lordship, is that the IC of Habra be directed to produce a CD before the learned trial court, because I am ready to face the trial. It is because of the police authority that the case is not proceeding, and the learned trial court is recording the fact that the petitioners are being harassed, my lord.
Lordship, thereafter what happened, Lordship, we don't know. This is the order of 15th March 2024.
Thereafter, my lord, the same thing is proceeding, my lord. The CD is not being produced.
Person on CBR present by filing Hajira. Learned PP charge is also present. Heard learned advocate for the defense counsel for consideration of charge. Charge was framed? No.
No, your lordship. No, your lordship.
I have not.
No, your lordship. No charge has been framed because the CD is not being produced by the police authority before the learned court. My lord, my prayer is an innocuous prayer. Only the CD be produced before the learned trial court, my lord.
Did the learned trial court pass any order directing IO to produce CD or
Lordship,
superintendent of police Howrah to produce CD?
lordship,
Can you show any order?
lordship, the order has been passed upon the learned public prosecutor of district Barashat, my lord. The order number 14, my lord.
That these orders ought to have been passed before the direction, with the direction upon the superintendent of police by the learned judge,
Lordship, but
learned
the
magistrate.
lordship,
To produce the CD.
That order was passed or not, Lordship, that.
lordship, no such order has been
concern?
passed, my lord. No such order has been passed, your lordship.
Why this revision application has been filed?
Lordship, for expeditious disposal of the trial, I am ready to face the.
Expeditious disposal, and we are praying for urgency. Can it be considered an urgent matter during vacation?
Lordship, for a very long period of time, lordship, is kept
Sure.
pending, lordship.
Before regular bench. Order করে দেবে before regular bench. Sir, don't come with this type of application.
Item number 4.
I am for the petition item number 4. Malaysia, I am praying for the not today.
Not today. Tell.
Grateful. Grateful, Malaysia.
Item number 5.
But 5 IAPF. But here, the impugned order, which is before your lordship, passed on 11th of July 2024, directing, but your lordship kindly turns to the certified copy. But it is the Grihum Housing Finance Limited.
Sir, which order you have assailed?
But 11th of July 2024.
11th
got
of
it?
July?
2024, the certified copy is annexed. Number by this order, the learned judge has directed, kindly sees the ordering portion, it number 3. But the appointed Mr. Saurabh De as the advocate commissioner to take possession of the secured asset of mine, and the
All
This-
piece and parcel of about 2 quarters of land along with building advances about first floor.
with the police help. Number questioning this order, I have come to this court.
Residential house supervisor appointed advocate commissioner shall give position notice to the authorized officer.
But this order has been passed
Hmm.
on an application under section 14 of the Securitization Act. But your lordship will find at the very first the paragraph of the order of 11th July. But section 14 of the Securitization Act says, kindly says, our names are there, my mother name is there, Noyan Poddar, and others are me and my brother. Now, no copy of the petition. I have annexed the petition also. I have taken the certified copy. But kindly takes up the petition once. But here, your lordship will find miss case number 48 of 2024, where the Grihum Finance has made three of us, my mother, myself, and my brother as a party respondent, and my sister also, in the entire case. Not a single petition has been served on us. Ex parte, this order was passed for attachment of my property. This is number one. Number two, there is an arbitration clause. Your lordship kindly have a look to page 176 and 177. Here, the authorized, got it? 176 and 177. The kindly turns to 177. 17th.
What is the order previously passed by the learners today?
Only one order.
Here,
On the very first day, the order was passed.
Advocate will file staying for time to hearing grounded.
Yes, 18th of March 2024. This is an application under 14(1) of the Securitization Act filed by the complainant against the accused persons. Then 17th of May 2024, 2 days fixed for hearing, PO on leave. Learned JM in charge. Learned advocate for the complainant files a petition praying for time. Then next day this order was passed. Without giving me any notice, without serving me this petition, and where there is a clear case, they have kindly turns to the interesting part, page 176. On 17th of June 2023, this finance company appointed Sri Sunil Singh as the sole arbitrator. Kindly see the subject. 176, kindly have a look. Got it?
Yes.
Subject. 176. 17th of June 2023. Now, the company is appointing home loan agreement being number Swanso, containing an arbitration clause between ourselves and Noyan Poddar, but the petitioner before your lordship, Amit Poddar and Anik Poddar. Then 177. First paragraph. We hereby appoint you as the sole arbitrator and request you to enter upon reference and initiate the arbitration proceeding between the parties and adjudicate upon the dispute. Number one, what is the proceeding? This order was only served on, this communication was served on us. There was no arbitration proceeding. There was no award was passed by the arbitrator attaching our property. Now, this immediately thereafter, they have gone to the court below, the court of London Additional Chief Judicial Magistrate, North 25 Prakas, Barakpur, and got the order of attachment. Now, your lordship kindly sees another interesting part. Kindly sees my demand of justice. 167. Repeatedly, starting from 161. My lord kindly turns to
167, yes.
Yes, starting from 161. We have said that kindly give me the details. Then 164. Second demand of justice. Then 166. Third demand of justice. Then 168. Another interesting part. This is 13-4 notice. Got it? 168. This is the notice issued by the finance company to us. Possession notice under section 13(4). This is symbolic possession. Thereafter, your lordship kindly turns to page 173 onwards. On 27th of April 2023, page 175.
Yes.
First line. Agreement and the said dispute, difference and claims will be referred to the arbitrator to be appointed in terms of the said agreement. So, there was an arbitration agreement. My lord, got it? Now, page 176, the appointment of arbitrator was made on 17th of June 2023. But what is the outcome? Nothing has been given to us. No award was passed by the arbitrator. No arbitration proceeding ever held. But straightway, section 14 of the Securitization Act was invoked. And attachment position notice was given. Order was passed by the court below without giving any notice to us. We don't know this order. Section 14 tab. Yes.
Service Act আছে এখানে?
Well, this is the Surface Act. Section 14. আরে লেখো দিয়ে দাও না দিয়ে দাও
দিলেই হতো।
দাও না কি আছে খবর আছে? Well, I request your lordship to grant a stay on this. Otherwise, my entire property will go.
What is the provision that you have, notice has to be given to you?
But an application has been made.
14,
Yes.
1,
Hmm.
B, B 6, Roman 6.
Yes.
What is the affirming that the period of 60 days notice
Hmm.
as required by the provision of subsection 2 of 13,
Yes.
demanding payment of the
That you have
financial
made.
assistance has been served on the borrower.
Yes.
That notice has already been served upon you.
True. But at 13.2 notice has been served, we replied.
Yes.
13.4 notice was served, we replied. But at 14, kindly have a look to section 14. But we are on 14.
Yes.
Kindly have a look to section 14 once.
Hmm.
But without giving me any notice.
Hmm.
But this is natural justice. Without hearing me, the court has passed an order for attaching my property, ex parte, when I have been made a party respondent. When there is a specific appointment of arbitrator.
Sir, what is
Arbitration Act
written in the section 14? What is written in the section 14?
Kindly, may I read it for your lordship?
Yes, read it. Read it. What is the just to take assistance? One application has to be filed before the chief metropolitan
Yes.
chief judicial magistrate for taking position. Nothing more,
Absolutely.
nothing less.
Kindly see.
Only to take assistance. One application has to be filed before the chief metropolitan.
May I read it for your lordship?
Yes.
Chief Metropolitan Magistrate or District Magistrate
Yes.
to assist
Hmm.
the secured creditor for taking possession of the secured asset.
Yes.
Where the possession of any secured asset is required to be taken by the secured creditor,
Hmm.
or if any secured asset is required to be sold or transferred by the secured creditor under the provision of this act, the secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing the Chief Metropolitan Magistrate or the District Magistrate within whose jurisdiction any such secured asset or other documents relating thereto may be situated or found, to take possession thereof, and the Chief Metropolitan Magistrate, or as the case may be, the District Magistrate shall, on the request being made to him, take possession of such secured asset and documents so and so, forward such asset to the secured creditor, provided that any application by the secured creditor shall be accompanied by an affidavit affirmed by the authorized officer of the secured creditor declaring that the aggrieved the aggregate amount of financial assistance granted and the total claim of the bank as to the date of filing this application, the borrower has credited security interest over various properties, and that the bank or financial institution is holding a valid and subsisting security interest over such property, and the claim of the of the bank or financial institution is within the limited period, the borrower has created a security interest over the various properties, then the borrower has committed default in making payment. Consequent upon such default in making payment financial assistance, the account of the borrower has been classified as non-performing asset. Where is that? No, nothing. Only one application before the judge, and judge has passed the order, but without giving me any opportunity of hearing. But no opportunity of hearing will be granted to me. They will take possession of my property when there is an arbitration clause. But if there is an arbitration clause pending and an arbitrator has been appointed, but the arbitration proceeding is going on, how the court can take cognizance of this petition? But two proceeding cannot run simultaneously. But your lordship knows better than me. They have invoked arbitration. They have appointed sole arbitrator. No arbitration proceeding took place. No notice was served on me. No award was passed. I could have understood that yes, an award was passed. So to comply that award, this section 14 notice is required to be complied with.
13.
Section 14. Section 14 is power to attach.
Yeah.
Now, section kindly sees, nothing has been done. First, they went to the arbitration proceeding, appoint an arbitrator. This is sole arbitrator appointed by them, the financial company, not by us. We have not been able to declare our stand. How much we have paid? Kindly sees my reply once. What more a person can do? Kindly, your lordship kindly sees reply by the petitioner. 124. Kindly comes to page 124 once. Kindly turns to 124. This is against notice under section 13(4) of the Securitization Act. Just now my lord has read. (127) operating part. My lord got it? We have mentioned the entire detail. 127. In view of the above awful and circumstances, I am to state that the demise of my father, the only earning member of our family, coupled with COVID-19 pandemic situation, financially resulted, which our business has been totally ruined. I am not in a position to repay the loan, repay the amount as your honor asks for by your notice. I could only be able to settle all accounts of my father, including my family, if your honor be kind enough to close the dues with a lump sum of 5 lakhs. This was made on 17th of February, December 2021. Then, next page, page 128. This is my mail to the company. As per my below mail, I want to know the loan amount along with full detail starting from 27th of June 2005. Loan account number so and so.
What is the loan amount? You took the loan.
No, my father took the loan.
Father.
Yes. He is no more there. Now see, I have already informed earlier also, but which I did not receive till date. If you want to know any clarification from my side, you can call me and point out the time, because I cannot wait so long. Neither I will ask several times the same. I request you to please do the needful as soon as possible within 5th March 2016. Then continuously, next page, please send the total outstanding of my house building loan as on date. Nothing was replied.
Who took the loan?
My father. We are the guarantors. Now your lordship can listen. Now my father has expired. Kylie turns to 130. The company is writing us 130. With reference to the enclosed mail, we would like to inform you that the matter is under our review and we will contact you in this context at the earliest. Request you to bear with us in the meantime. Your feedback is valuable for us to serve you better. Then on that page, Amit Podar, please send me the total outstanding of the house building loan as on date. Continuously, my lord, I am writing to them. Kindly give me the detail. How much is due and payable? They have not answered. Page 142. I have, my lord, mentioned once again that, my lord, kindly give me the details so that I can pay. I want to pay. A property of more than 4 crores against my lord, outstanding of 28 lakhs. And that too, my lord, without giving me any notice.
Petitioners had sought for a loan of rupees 20 lakhs. An amount of 9 lakhs 9,211 had been released from the
Yes.
state. Magma Housing.
Yes, that was in Magma. That was Magma Housing. Thereafter, Punawala, my lord, loan housing. Thereafter, Gruhum.
Why the change of the
But this is my lord, between them. I have the documents that the company has.
amount of rupees 11 had never been
Yes, the
released?
company has changed. Yes, I have annexed that.
So according to you, sought for loan 20 lakhs.
I sought for loan for 20 lakhs. They gave me only 9 lakhs. Now they are charging 20 lakhs and odd.
Lakhs balance.
I have paid 5 lakhs. Let me serve a notice to them. Let them come before your lordship.
Revision application has been filed, assailing the order. Selling an order passed on 11/7/2024 in connection with miscase number 166 of 2024 by the learned additional Chief Judicial Magistrate, North Chobbish Pargana, Barakpur, allowing an application under section 14 within bracket 1 of securitizing and reconstruction and financial assets and enforcement of Security Interest Act 2002. And in response to next para, in response to that application, an additional Chief Judicial Magistrate passed an order by appointing one advocate commissioner to take possession of the secured assets against the loan against the due to the.
But at page 122 and 123, this is the change of company.
Okay. Due to the petitioner company.
No, petitioner is me.
Yes, petitioner. Who is the petitioner? Opposite party, no? Division application due to the opposite party. Slash, who is the opposite party now? Now, who is the opposite party? Who is the opposite party? Opposite party is Griham Housing Finance Limited, na? Slash the Griham, Griham Housing Finance Limited slash OP number 2 herein. Due to na? Due to which na? Okay. Top. কি লিখলেন একটু বলুন প্রথম থেকে। হ্যাঁ। Secure assets of the petitioners. What is it? Secure assets of the petitioners. Secured as against the loan. Take it. Full stop. Whatever. And counsel appearing on behalf of the petitioners submitted that there was an there was an agreement between the parties and clause and with a clause of appointment of arbitrator in case of any dispute. It has been further submitted. No, full stop. Counsel appearing on behalf of the petitioner has further drawn my attention to the to a document issued by the finance company regarding appointment of school of arbitrators. Full stop. Under an ঠিক আছে sole arbitrator ঠিক আছে full stop. It is submitted that arbitration proceeding it is submitted that no award has already been and no award has ever been promulgated by the arbitrator in respect of the dispute between the parties, but instead the opposite party filed an application before the Chief Judicial Magistrate, Additional Chief Judicial Magistrate, North Chowbish Pargana, Barakpur, with a prayer for taking position of the
civil court has
secured assets. Step. For a parent, given facts and circumstances, I find that I'm of the opinion that dispute between the parties. No, dispute between the parties in this revision application is required to be deliberated. No, is required to be deliberated. Is required to be heard in presence of both sides. The petitioners are directed to serve notice through register post with AD. Serve notice upon the opposite party. Only opposite parties to opposite party number 2 to register post with AD. And also to serve notice upon the state through public prosecutors. Public prosecutors. And to file affidavit service on the returnable date next, given facts and circumstances. Nah, in response to, did you make any prayer for interim order? No.
but yes.
Where it is? Pending hearing, rule granted interim. Okay. In response to the prayer on behalf of the petitioners,
Page 17.
interim order of stay. In this one, learned counsel. Counsel appearing on the petition has submitted that an interim stay of operation of the interim order should be passed. Otherwise, purpose of this revision application shall be frustrated next forever. Given circumstances, the order dated 11th July 2024 passed by learned additional Chief Judicial Magistrate Barapur in connection with this case number 166 of 2024 be stayed for 6 weeks or until further order, whichever is that. Let the matter appear before the regular bench. Huh? We stay 4 weeks. After 4 weeks.
I have just now hand over the arbitration. Kindly have a look. Section 42 of the Arbitration and Conciliation Act. No, when Arbitration Act is invoked,
Okay.
no court has any jurisdiction to take up this issue. I'm grateful to you. Grateful.
Chalo, Tabar.
Grateful.
Item number 6.
Madam, for the petition.
Item 6.
6. Yeah,
But this is the supplementary affidavit along with the petition. But this is a 138 proceeding. 138 of the Negotiable Instrument Act. But in the 138 proceeding, the complainant filed an application under section 143A for interim compensation. But without considering any aspect, but the learned magistrate with due respect awarded the compensation to the tune of ₹20% of the total amount. But total amount was 70 lakhs. But it was a business transaction. Out of 70 lakhs, 8 lakhs rupees already been paid. But rest amount 62 lakhs. But 20% the learned magistrate has awarded. Your lordship will get the order in page 23.
Dated 22nd July.
Yeah, that is Sessions Judge's order. The magistrate order page 23 of my petition. Order dated 3rd of June 2023.
You have assessed this order 22nd 7 July.
Yes.
July 2024.
Yes.
What is the order?
Page 23, annexure P6.
Page 23.
Yes. Only consideration was that because of the pandemic, the petitioner could not appear before the court. So the complainant is suffering. And as the statute mandates, although it was a wrong quotation of the section, statute doesn't mandate. Your lordship knows better than me. 143A says, the court may consider. It is not shall. But the learned magistrate, with due respect, he considered to be a shall and awarded a compensation of ₹20% of the total amount. This was deprecated by the Honorable Supreme Court very recently. I have a judgment.
Learned advocate was accused, raised vehement objection. You also appeared.
Yes.
You also appeared on that.
Yes.
3-6. When the order was passed, the existing law stipulated 140 to our interim compensation arising out of dishonour checks and that interim order must be paid within 60 days. It is important to understand that intent behind the production partnering to dishonour checks because delaying tactics of the debtors thus to provide relief during pendency of the proceeding to the complainants who are waiting for years on account of and so.
Lordship knows since 2020, the entire the country was under the COVID period was going on. And ultimately in 2022, he was examined under section 251 of the CRPC and interim compensation was granted. Now, kindly see the statute once.
What is the stage of the proceeding now? 251 CRPC was done.
Yes. Now, only the complainant has been examined. 251 CRPC, as your lordship knows, 143 says it may extend to 20%,
but it depends upon the case to case basis.
Hmm.
Let kindly see it, Milord, once. 143. 143A. Kindly see section 2. Now, this was further clarified by the Honorable Supreme Court. Before that, but I shall take your lordships to the order passed by the Landed Sessions Judge.
Shall not exceed 20%.
My lord will get it in page 29, annexure P8. That the Landed Sessions Judge, with due respect, he says, Lord, the magistrate was under obligation to pass such kind of orders.
Court shall direct the complaint to pay the within 60 days. Within such period,
Now, my lord, kindly turn to the order passed by the Landed Sessions Judge, page 29. Page 29.
20?
29 of my petition.
Yes, yes. 29.
Annexure P8. My lord, the relevant is page 30. My lord, the third para. But it says on plain reading, well, got it, page 30, on plain reading of such section, it transpires the learned magistrate court was under obligation. My lord, kindly marked it here. Now, Supreme Court very recently, my lord, has clarified that the scope of 143A. My lord, if you should kindly take this. Para 11, there is a 2024 judgment. Para 11, my lord, kindly come. Mandatory or directory? My lord, got it. There is no doubt that a word may ordinarily does not mean must. Ordinarily, may will not construct as shall, but it is not an inflexible rule. The use of word may, certain legislation can be incorporated as shall, and the word shall be constructed as may. It all depends on the nature of power conferred by the relevant provision of the statute and the effect of exercise of the power. The legislative intent also plays a role in the interpretation of such provision. Even the context where the word may have been used is also relevant. Now, my lord, kindly turn to 18. Para 18 of the judgment. My lord, got it? Para 18. In a case under section 143A, power can be exercised even before the accused is held guilty. The subsection 1 on 143A provide the passing a drastic order for payment of interim compensation must be the accused in a complaint under 138 even before the adjudicating the guilty of an accused. The power can be exercised at the threshold even before the evidence is recorded. The word may is interpreted as shall, and it will have a drastic consequence as even the complaint under section 138, the accused will have to pay compensation up to 20% of the check amount. Such an interpretation will be unjust and contrary to the well-settled concept of fairness and justice. It must, the interpretation is been made the providers of the manifest of the arbitrariness. The provision can be held for the violative of Article 14 of the Constitution in a sense of section 1 of section 143A provides for penalizing the accused even before he is guilty or established. Now, my lord, kindly come to para 23. My lord, what should be the consideration before the learned magistrate? Para 23.
Para?
23, 2-3, my lord. Even if the court concludes that a case is made out for grant of interim compensation, the court will have to pay its apply its mind to the quantum of interim compensation to be granted. Even at this stage, the court will have to consider various factors such as nature of transaction. In our case, it's a commercial transaction, and it is admitted by the complainant himself. The relationship, if any, between the accused and the complainant and paying capacity of the accused. If the defense of the accused is found to be prima facie a plausible defense, the court may exercise direction in refusing to grant interim compensation. 24. We may note the factors required to consider which have been set out as above are not exhaustive. The court may several other factors in the facts on a given case, such as pendency of any civil suit, etc. While, this line is very important, while deciding the prayer under section 143A, the court must record brief reasons indicating consideration of all relevant factors. In our case, your lordship will find neither by the learned magistrate nor by the learned sessions judge has given any reason for interim compensation up to 20%. Now, my lord, pursuant to the direction, my lord, now the warrant also being issued, my lord, in a supplementary affidavit, I have placed before your lordship.
Where is the warrant order?
Page 9. My lord, just now I have handed over the supplementary affidavit. My lord, kindly stay the both the order and also the warrant of arrest. This is contrary to the law. Your lordship knows better than me. Page 9. Page 9.
The order was passed by SCJ.
Yes, my lord, SEGM. My lord, we have indicated before the learned court below that the revisional application is already pending before the honorable court for proper adjudication.
This revision application, challenge in this revision application is the order dated 22nd July 2024, passed by learned session judge at Barasat, North Chowbish Pargana. Wherein learned judge, what is the order of July? Wherein the learned judge affirmed the order passed by the learned SCJM, learned SCJM, learned SCJM Barakpur, SCJM Barakpur,
My lord,
SCJM Barakpur,
Bidhannagar, my lord.
SCJM Bidhannagar. Affirming the order of learned Bidhannagar with regard to awarding compensation, interim compensation, invoking section 140, 143 within 143A, capital A, of the Negotiable Instrument Act. Illegal direct direct instrument directing the petitioners to pay 20%.
Yeah, 20%, total amount 12,40,000.
20% of the amount of a check. Full stop. Learned counsel appearing on behalf of the petitioner has submitted that the order impugned lacks the reasons for granting interim compensation invoking section 143 capital E of the NI Act. Next para, it has been further submitted that learned session judge recorded his order affirming the observation of the learned additional Chief Judicial Magistrate Bidhannagar on the ground that that Learned Trial Court was under obligation to award interim compensation in case of dishonor of checks. Dishonor of checks within the period, within the statutory period mentioned in the provision itself. Full stop. Next paragraph. Counsel appearing on behalf of the petitioner also relied on a case, also and also submitted that learned additional Chief Judicial Magistrate Vidhan Nagar, North 24 Pargana কথাটা লিখবেন, passed an order directing issue of warrant against the accused by the order dated 5/10/2024 in connection with C case number 2336 of 2019. Full stop. Next fact. When counsel appearing on behalf of the petitioner has submitted that no specific reason was assigned in the order impugned as well as the order passed by the learned ACJM Vidhan Nagar before invoking the provision of section 143A capital A of the Negotiable Instrument Act. In support of his submission, he relied on a case reported set out this Rakesh Ranjan Srivastava versus State of Jharkhand and another, reported in 2024 volume 4 Supreme Court cases 419. Counsel appearing on behalf of the petitioner specially referred to the paragraph 11, 19, 23, 24 of the case of Rakesh Ranjan Srivastava within brackets Supra. Full stop. Considering all facts and circumstances, as well as after having gone through the all documents, relevant documents in this case, as well as what is this supplementary evidence, and as well as the documents filed with Kilo. Okay. Given facts and circumstances, I find that it is an arguable case to be heard in presence of both sides. Accordingly, petitioners are directed to sub-notice. Petitioner is directed to sub-notice upon the opposite party through register post with AD and to file affidavit of service on the returnable debt. Full stop. Next paragraph. Counsel appearing on behalf of the petitioner has prayed for an interim order of stay of operation of the order impugned. Otherwise, the purpose of the revision application will be frustrated. Full stop. It has been further submitted that order of issuing warrant passed by the learned additional chief judicial magistrate Vidhan Nagar, North Chhattisgarh Pargana is also required to be stayed. Stayed, required to be stayed. Full stop. Forever. Having heard learned counsel appearing on behalf of the petitioner, as well as having gone through all the relevant documents, I find it necessary to pass an order of stay of the operation of the impugned order. Impugned order dated কত বলেছি? Dated 22/7/2024. Passed by the learned session judge as far as 24 Parganas in connection with criminal, in connection with criminal revision number 242 of 2023. Affirming the order of the learned additional chief judicial magistrate Vidhan Nagar, North Chhattisgarh Pargana in connection with 2336 of 2019. Full stop. Consequently, next para. Consequently, the order passed by the learned SGM dated 5/10/2000. আচ্ছা ওইটা কি হলো? এটা স্টে হলো তো? Stayed for impugned order কি হলো? লাস্ট stayed 6 weeks দিয়ে দেবে। Criminal revision. কমা দিয়ে না consequently ছেড়ে দিন, কমা দিয়ে বলুন till 6 weeks hence or until further order whichever is earlier. Next para. Consequently, the warrant of issuing order dated 5/10/2024 passed by learned additional chief judicial magistrate Vidhan Nagar, 24 Parganas. Issuing warrant against the accused be stayed for 6 weeks hence or until further order whichever is earlier. Let the matter placed before the regular bench.
Deeply obliged. Deeply obliged.
এটার উপরটা দিয়ে দেবেন কস্ট টাইটেলটা, পোস্ট টাইটেল আর নেক্সট দেখুন
Item number 7.
7 I am for the petition, Your Lordship.
What is this? Huh? এটা কি হলো? Please.
Lordship, I am for the petition. May it be pleased, Your Lordship. Lordship, in this application, Lordship, the petitioner, being the aggrieved wife, filed this application challenging the order passed by the learned session judge in criminal appeal 37 of 23, Lordship.
Page 71.
Lordship, kindly comes to page 71.
What is the urgency, sir, in this case?
Lordship,
What is the
Lordship, the
urgency?
urgency is that, Lordship, I'm not paying any interim order, Lordship. Only a direction may be served upon the petitioner to serve a copy of this revisional application. Already, Lordship, by challenging that order, the husband has got an interim order passed by this Honorable Court, Lordship. And by that order, Lordship, the husband is not paying regularly maintenance amount as directed by the 125 court and also the DV court and also passed by the learned sessions judge and also passed by this honorable court in revisional application preferred by the husband, Lordship.
So go to that
Lordship,
regular bench.
Lordship, a
Why
copy may be
praying
served.
this application?
Lordship, a copy may be served upon the opposite party, Lordship, and a direction so that this application can be tagged with that revisional application preferred by the husband, Lordship, so that both can be heard simultaneously, Lordship. Otherwise, I will be
Why
prejudiced.
CRR? Which order you have assailed in this?
Lordship,
CRR
that
1710,
Lordship, no.
2023. You have assailed an order dated interim maintenance passed by the learned judicial magistrate.
Lordship,
Which
the
order
page
you have assailed?
71, Lordship.
Sir, you have cost title. Please see the cost title of your revision application. Seventeen five.
Lordship, all the impugned order is written in the cost title, Lordship.
All the impugned orders.
Lordship, only I am referring this application only by challenging 17/5/2023 order, Lordship.
What is the order? Did you annex? Certificate copy
Lordship,
of the order.
it is annexed at page 71, Lordship.
Sir, did you annex the certified copy of that order?
Certificate copy.
Next. Chalo. Before the regular bench. Next. Sure. No, which order? Before the regular bench. দিয়ে দিন এক লাইন যা হচ্ছে এক লাইন করে অর্ডার দিয়ে দিন let the matter appear before the regular bench করে দিন next part রাখুন
Item 8.
8 yes
Your Lordship, this application has been filed under Article 227 of the Constitution of India.
27
The Constitution of India.
27 আচ্ছা
It is regarding getting remedy and challenging an order passed by the learned session judge South 20 Pargana Alipur on 12th October 2023 pertaining to one criminal motion that has been filed before this learned session judge at Alipur, criminal motion number 439 of 2023. And this criminal motion has been preferred under section 397 read with 399 of Criminal Procedure Code.
Prayer for stay of operation of order was refused.
Was refused.
It was admitted. Motion was admitted.
Motion was admitted.
But your prayer, let them appear before the trial. Before
No, I have urgency. This particular criminal motion has been preferred against an order of 20th passed by the learned 9th Judicial Magistrate Alipur on 20th September 2023 in regards to an application filed under section 143A of Negotiable Instrument Act.
143A.
Yeah.
It was passed. Order was passed.
Order was passed.
What is the order? Sir, did you annex it?
No, my petition is pertaining to the relief that I want to place against the order of 12th October 2023, refusing the stay. Because against this order, I have filed a criminal motion.
No, sir. No, sir.
And sir, because...
Where is the order you have assailed before the learned session judge? What is the order?
That has been annexed, the certified copy. In the certified copy,
you have annexed the order passed by the learned session judge.
Session judge.
What is the order assailed before the session judge? Copy of the order.
That order I have craved leave for filing this. That actually I have craved leave to file that order.
That order You have not annexed here. There is nothing mentioned about which order was passed by.
That
which
I
court.
mentioned, I mentioned, I'm just, I'm coming to the relevant page, sir.
Impugned order, the peruse the certificate copy of the impugned order, case in case. It appears no stay. Stay was granted. Yes.
Sir, please come to page 27. Uh,
27, it is in the petition.
27, paragraph number 51. The learned session judge on Talipur, upon hearing the stay petition filed, the petitioner was pleased to pass an order on 12/10/2024, not allowing the prayer of staying proceedings containing the stay petition in respect of the complaint case being C5847/2019 before the learned judicial magistrate 9th court at Alipur. The aforementioned criminal motion was transferred. And prior to that, at page 26, paragraph number 49, I've mentioned the petitioner contested the aforementioned application of the opposite party under section 143 of NI Act by filing a written objection. Learned court upon hearing was pleased an order on 20th September 2023 directing the petitioner to make a payment of sum of rupees 3 lakhs to the opposite party.
So it was not paid by you.
And sir, in this matter, I like to brief certain events prior to this filing of this case. The respondent and the petitioner. I'm representing the petitioner who is accused in the NI Act case in the trial court, and the respondent is the complainant. Now, complainant and the accused, they are related. The respondent, the accused in the trial court is the elder brother of the complainant.
So it didn't repay the money.
No, actually, what has happened? The check. There are the complainant. The complainant is the younger brother of the accused respondent. Now, accused complainant in this case is the eldest brother. They have a family of 5 brothers. Now, this accused, my client, he has been, being the elder brother, he has reared up all his brothers up to their adulthood and even helped them out in doing their business. They used to do 3 separate business with 3 separate entities in the same house, same premises as their address.
This revision application.
And my case is that
try to maybe there is some relationship. They are brothers. I'm not on that now at this stage. At this stage, your prayer is your stay, operation of stay of the order was refused by the district.
By the session judge has been refused.
So serve notice and come both sides, matter will be heard. I'm not going to pass any stay order, sir.
Sir, actually there has been an interim order of urgency, that's what I'm saying. After not
Show me the order issuing warrant against you. Show me the order. Sir, collect it. Move before the next vacation bench. Okay. You have to show the urgency. Warrant has already been issued against you. As you didn't comply within 16 days, 60 days you didn't comply by paying the interim.
Sir, the warrant order.
This order, warrant order. What is the which order, sir? Warrant? None appears DW against accused person. What is the warrant?
This is the warrant order.
20th
July, the order has been passed.
20th July?
2024.
You are still at large. You are still at large.
2024, 20th July, this order has been passed. Actually, Sir, there has been a DW, prior to that, the learned court himself has passed an order that they are going to wait for the order of the sessions court to come up. I have sent the relevant order that has been passed on 20th December 2023. But on the next order, very order, the order has been changed. They have issued the DW warrant. Thereafter, without the
DW issued when?
DW issued on 25th April 2023.
That was 23. Then,
2024.
then warrant was issued in 24.
Just after 2 months.
This is DW.
Sir, kindly have a look to the order of the 20th December. 20th December 2023. That in the last line there it has been stated.
39. Challenging the order dated passed by the instant 143 NI Act Planet. Honorable Appeals Court India, filed by Honorable Appeals Court decided that in default and payment on defense of the accused shall not be struck out. In the alternative, such interim amount can be realized only as a realization of the 142. In view of the pending criminal division, this court is not inclined to pass any further order in such matter, awaiting.
In the last line, the learned court itself has stated that they are going to wait for the outcome of the Harvard court. But on the next order again, they issued the DW. And on the third order, the order thereafter, they have passed the warrant. The learned court is held bound to recover the money.
It was 19th March 2024 was fixed next date. On that date, fix for fix 25th for 24 for cross examination. Then on 24th is not found, accused was not found, none appears.
Hajira has been filed.
DW against the accused person. So this warrant order was for what? Which is, sir?
On 20th July 2024.
20th July. That is after 24th April. April it was DW, then warrant. What is the order of passed by the learned trial court? 43A.
Your lordship will to go.
Hey, come. Yes. This revision application has been filed, assailing the order dated 12/10/2023, passed by the learned session judge Alipur in criminal revision number 439 of 2023. Within bracket likhun criminal motion number 54 of 2023. Bracket, new number. Whereby not allowing the by not allowing any stay of the order dated 20th September 2023, passed in criminal miscase number C5847 of 2019, passed by learned judicial magistrate 9th court at Alipur. Full stop. Learned counsel appearing on behalf of the petitioner has submitted that on 20th September 2023, learned magistrate Learned Magistrate, Ninth Court Alipur, has passed an order directing compensation to the tune of rupees 1,50,000 to the opposite party. Who is the opposite party? The revision application, who is the opposite party? Javed, huh? To the opposite party, na? Opposite party hearing. Invoking the provision of section 143A, capital A of the Negotiable Instrument Act. Next paragraph. Learned counsel appearing on behalf of the petitioner has submitted that learned judicial magistrate, learned magistrate invoked the provision of section 143A without assigning any reasons whatsoever. Full stop. And that order, no, full stop. And that order was the same before the learned session judge in criminal revision number 439 of 2023, wherein learned session judge refused to, though admitted the revision application, but admitted the motion, but refused to stay the impugned order dated 20th September 2023, and consequently, learned judicial magistrate passed an order issuing warrant against the petitioner herein. Against the accused / petitioner herein. Learned counsel appearing on behalf of the having heard learned counsel appearing on behalf of the petitioner, as well as having gone through the all relevant documents, including the impugned order, the petitioner is directed to serve notice along with the copy of the revision application upon the opposite party through register post 230, and to file affidavit of service on the returnable date. So which next learned counsel appearing on behalf of the petitioner has submitted that order issuing warrant passed by the learned magistrate is required to be stayed. Otherwise, the entire purpose of the revision applications shall be frustrated. Full stop. Having regard to the all facts and circumstances, the order of so did you make any prayer for stay? No. Did you make any prayer for stay?
Yes, sir.
Where is? Yes. Which order you have prayed? Operation of
Yes, Lordship,
proceeding.
kindly,
See case number.
kindly have a look to page number 37. To pass, on the last line itself, to pass an interim order of stay of the order dated 10/2024. And also I mentioned in the page number 38, in the last, in the middle part, to pass an interim order of stay of order dated to 20th/7/2024, passed by the learned judicial magistrate, 9th court at Alipur.
Which order? That order?
Of the order of the or warrant of arrest.
WA. করো, এটা লিখো। কি লিখলেন? Circumstances. And the order issuing warrant by the learned magistrate in the order dated, which order? 20th
20th July 2024.
Be stayed till the disposal. No, be stayed for 6 weeks. করে দিন। Be stayed for 6 weeks. Or until further order, whichever is earlier. Let the matter before the regular bench appear before the regular bench within 4 weeks. করে দিন। After 4 weeks. After 4 weeks, 3 weeks চলে যাবে in the meantime. চলো।
Much obliged.
Next. This is. এইটা। Hey.
Wait, please, your lordship, my lord.
Which one? 9. Yes.
Lord, may I just place 3 pages, my lord, for your lordship's consideration in this matter, my lord. But if your lordship would be kind enough to take up page 48, my lord. But what happened was, my lord, the commercial transaction was going on. The opposite party made some advances. After that, they cancelled the order. And thereafter, they started seeking refund. In the meantime, my lord, we had processed the goods. We asked them to take delivery of the order. They refused. My lord, they register an FIR in Rajasthan. Rajasthan, my lord, we approached the Rajasthan High Court, my lord. We secured an order for no coercive action there. No coercive steps to be taken in that FIR, my lord. Right after that, my lord, they come back to Asansol, register another FIR in Asansol. My lord, long and short, my lord, same story. It's a replica of the Rajasthan FIR with just jurisdictional improvement here. My lord, the Honorable Rajasthan High Court.
What is the urgency, sir?
My lord, now, my lord, we are facing arrest in this matter. My lord, we are being repeatedly sent 41A notices. But in the
where is the urgency? What is the urgency?
But your lordship kindly considers, my lord, we are residents of Rajasthan, my lord. Now, my lord, otherwise, my lord, in a proceeding,
go to the regular bench.
My lord, this
I'm admitting it. Admitting it, directing you to serve notice along with the.
Yes, my lord, kindly gives me that protection, my lord, so that I don't have to travel from Rajasthan, my lord. Just that much, my lord.
No, not at all. This
my lord, my lord, kindly
revision application has been filed.
But if I may beseech just one indulgence, my lord, if your lordship kindly directs, my lord, just no coercive steps in this FIR, my lord. Otherwise, my lord, kindly appreciates, my lord, my lord, kindly just consider page 69 once, my lord.
What is the amount due, sir?
My lord, it's my lord.
Make any part payment?
It's not due, my lord. We are ready to deliver the goods, my lord. The police can come and seize the goods as well. It's ready, my lord. We have repeatedly sent notices, my lord. There are 2 notices, my lord. The last time also we have sent a notice on 21st of August.
How much money?
My lord, the total
delivery of
my lord, the total contract value was of 92 lakhs, my lord. We have already made part supply, part payment, my lord. Till about now, my lord, about 70 lakhs worth of goods are lying in our godown, my lord, which they are not accepting.
No, come. Listen.
My lord, kindly just
application, no coercion.
My lord, kindly consider page 69 once, my lord.
Find any urgency, sir. Only.
Well, kindly just consider page 69 once, my lord.
41 notice. Go to the police in response to 41 notice.
My lord, may we do it? My lord, may we do it through video conference just?
Revision application has been filed challenging the proceeding in connection with FIR number 279 of 2024 dated 14/8/2024 under section 420, 406, 506, 120B of the Indian Penal Code. pending before the police, pending before the CJM, Chief Judicial Magistrate, Paschim Bardhaman, in connection with complaint case number 463 of 2024, filed under section 156(3) CRPC. CRPC.
But kindly appreciate, my lord, this is a proceeding bad in law, my lord. This would be my only remedy under 482, my lord.
Sir, it
Because
has to be hard,
even
sir.
in
It has to
otherwise,
be
my
hard.
lord,
Revision application will be hard on it, on its merit. How can it be decided at this stage?
no, I'm only praying for a stay, my
Urgency,
lord. I'm only praying for a stay.
Not stay.
My lord,
Which
tightly
stay?
considers, my lord, in same
stay?
facts, my lord, the
No proceeding,
sister high court's order, my lord.
just FIR was lost. Go and file an application before the regular bench. Kurun, hoiche? I do not find any urgency. Huh? CRPC. Hoiche? 156. Whatever. Land counsel appearing on behalf of the petitioner has submitted that the proceeding was initiated in spite of readiness on the part of the petitioner to deliver all the goods. With regard to a commercial transaction between the parties to distribution applications. Next, after considering all the facts and circumstances, the distribution application stands submitted. Petition is directed to serve notice upon the opposite parties. Petitioners are directed to serve notice upon the opposite party number 2 through speed post with AD. Notice along with the copy of the revision applications upon the opposite party number 2 through register post with AD, and also upon the state through public prosecutor of this court, and to file evidence of service on the returnable date. Let the matter appear before the regular bench on. When I will fix that?
On any day subject to your lordship's convenience, my lord, in the reopening week itself, my lord. Opening week itself, my lord. My lord, may I just seek for one indulgence? My lord, just one innocuous direction, my lord.
Court. Let the matter be on 4th.
My lord will kindly grant us just one liberty, my lord.
Next.
That is to, my lord, the investigating agency may just at the preliminary stage examine us through video conference, my lord. May we comply to that 35(3) notice virtually, my lord. Just the 41A notice, my lord. May we comply with it virtually, my lord, through video conferencing. My lord, we'd provide our email ID. We'd provide our email ID to the investigating officer.
Come. Target. Now, counsel appearing on behalf of the petitioner has submitted that in response to the notice under section 41A of CRPC, the liberty may be granted to the petitioners to appear virtually after supplying virtually to appear virtually before the investigating officer by supplying the email address. Email or by email, sir?
For the purposes of the link and examination.
Email address is not required.
But we'll communicate our whereabouts to the investigating officer. They would examine us virtually, my lord.
Liberty is granted. Yes, liberty is granted. Yes. It is submitted on behalf of the petitioner that all the petitioners are resident of Rajasthan. Agerpada. It is learned counsel appearing on behalf of the petitioner has submitted that all the petitioners are resident of Rajasthan. So liberty may be granted to respond the notice under section 41A of the CRPC virtually. পরের প্যারা বাকিগুলো কেটে দাও, বাকিগুলো কেটে দাও, পরেরটা পরের প্যারা ভাই, পরের প্যারা যেন liberty is granted subject to subject to appearance before the investigating officer if so required for the purpose of investigation. Next, chalo. Next part is the
Item number 10.
But I appear for the opposite party number 2.
What urgency, madam? I have to dispose of this revision application today. No. Then can I pass any order directing the possession delivered to you by the finance company? Can I pass any order without hearing on merit this revision application? Okay, madam, I know. Can I dispose of this revision application? What is the urgency? You are already ousted from the property. Entire building you are occupying the part. Sir, entire building of the premises you have
First of all, this application is not maintainable. Lordship knows it's a section 14 order. The person has to challenge before the DRT. Section 17 is there. But 26th April 2024 is the date of order passed under section 14. Now, 26th April. They had a limitation of 45 days. Now they have filed a recalling application, which obviously got. We have implemented the order in terms of the order, and if there is any grievance, they may approach the DRT if the law permits.
So this revision application has to be disposed of. How can it be? What order you are seeking today?
Before the financial benefit extended by the order, definitely they have sourced all the
So, madam, go to the regular bench. Regular bench, they have appeared, they have entered appearance in this case. So, no order need be passed. That is the prayer of your revision application, sir. Why can this be allowed without hearing? Come. Both
But
the,
kindly keeps the issue of maintainability open.
both the learned counsels appearing on behalf of the parties to this revision applications are present. Considering the nature of prayer. Okay, I understand, madam. Considering the nature of the prayer, considering the nature of the prayer of the revision applications, I find that the issue involved in this revision application is required to be heard required to be heard. Okay, required to be heard in full. Required to be heard at length. Required to be heard at length. Considering the matter be listed, matter be placed before the regular bench on 4th October. 4th খুলছে তো?
But kindly keeps the issue of maintainability open.
কবে খুলছে? কবে খুলছে?
4th of November.
4th November. 4th November.
But kindly keeps the issue of maintainability open, my lord.
When your position was taken? Next, point.
My lord, only one submission, my lord, kindly keeps the issue of maintainability open, my lord.
Sir, madam, your urgency will continue till 4th November. No problem. It was filed in the you are dispossessed in the year in the month August.
My lord, kindly keeps the, my lord, only one submission, kindly keeps the, the maintainability issue, my lord, point of maintainability.
পরেরটা ডাকুন 12. Who is 12? Come. Revision application কে আপনি? কোনটায় আপনি আছেন? আমি দিয়ে দিয়েছি 9 তারিখে হবে। নেক্সট পরেরটা ডাকুন। আপনি 4 নভেম্বরে যাবেন। এটা পুরো ডিভিশনে সবাইকে দুজনকে শুনতে হবে, উনি অ্যাপিয়ার করে গেছেন। আর স্টে দেওয়ার মতো কিছু এক্ষুনি নেই, আপনাকে ওই ফ্ল্যাটে আবার ঢোকাতে হবে। দ্যাট হ্যাজ টু বি দ্যাট ইজ সেইটা আপনি অগাস্ট মাস থেকে হয়ে আসছে। ঠিক আছে, এবারে 4 তারিখ পর্যন্ত অপেক্ষা করুন, সেই দিন হবে। নেক্সট পরেরটা ডাকুন। ইয়েস, হোয়াট ইজ ইউর কেস? Page 9. কি রেখে দিয়েছে, কি পারমিশন দেয়? হ্যাঁ, ইয়েস, ইলেকট্রিক 9, page 9. Which order you have assailed, sir? First show the order you have assailed. Where is the order? Where is the order you have assailed? Under section schedule property. What is the order? Is permitted to take physical possession of the immovable property of the respondent.
Now, I am the tenant of the respondent opposite party number 4. Now, my lord, I have been out, I am going to be outfed by the police, by the order of the landed magistrate under section 14. Whether
What is that order? For display, that was passed in the month of July, madam, sir.
I have come to learn, so you can see, I have come to learn.
Sir, serve notice and come. That will suffice. Come. Learned. Where is that order? Supreme Court judgment? The Navun Digi? He order Digi? Where? Where is the order? Where is the order? Which is the paragraph? Paragraph. Show me the paragraph. Sir, don't waste my time. Paragraph. Show me the relevant paragraph of honorable observation of the honorable apex court.
Yes, you have to 93. But I have been
60? Paragraph. Paragraph is there. Paragraph are there. All are. Huh? Which paragraph? Which paragraph you are reading? So. How many paragraphs are there? 28 paragraphs. Which paragraphs you are relying on? Huh? Chantruna.
There are two applications going to the Supreme Court. There are a lot of applications in this matter. What is one was the leaseholder and another one was the tenant. Now, coming forth together, the Honorable Supreme Court at the matter and found that Advocacy Act does not say that any statutory tenant or a statutory leaseholder should not be ousted without due process of law. This is the order. Honorable Supreme Court. And my lord, I am here,
Reading of second law of 34 surface to show no injunction shall be granted by any court of the action to District Metropolitan Magistrate sought to be taken thus when action is sought to be taken further 13 Services Act or authority mentioned 33 morals the controller cannot grant
with this judgment and other laws, maybe difficult after getting evidence for the significant. In all this, at least the chief controller or the speaker maybe will pass final order.
injunction to
By other the Leslie
side.
This is the government under the government outfit. I am there to take, I am not a party in the Muslim. I do not know anything. I am the tenant.
Who is the borrower of it? Oh, you are the tenant.
Yes,
Borrower is the landlord.
yes.
And the tenant under landlord who is borrower, landlord who is borrower secured as a tenant and not the dispute between the secured creditor and the tenant. What is the observation of the Honorable Apex Court with regard to your protection? Where? The contention of the respondent of the appellant have not produced in a document their bona fide lazy or secured assets of the secured assets. We find that the cases before us you have relied on tenant under 7 Transfer of Property Act. Section provides the lease of immobile property from year to year. Huh? Not the dispute within security. They cannot grant it injunction. Prevent such action by the secured creditor. Injunction to prevent secured such action by the you are the tenant. What is the document? What is it? Page? Page?
Page 9, page 15, page 16, page 18. My date license, my city, my identity.
Page 16.
All I have there.
Lease. Huh? Tenancy. This is a lease agreement. Who are you? What's your name? What's your name? Client's name? Shaukat Ali. Municipal. Asun.
All municipal license will be 2017.
Regarding?
You can get license. This is 16. This 17 is 16. This 18 is 16.
Asun. Regular bench. Let it be heard by the regular bench, sir. Oh, all the learned petitioners. So I shall dispose of this revision application without giving an opportunity to the opposite party. No, sir. This revision application has been filed with the prayer for office. Sir, I am dictating the order. Sir, please. This revision application has been filed, assailing the order dated 3rd July 2024, passed by the Honorable Chief Judicial Magistrate, directing Barasat Police Station to render necessary assistance of necessary assistance to give physical possession of the civil property. You didn't challenge this order before the district court? No.
No.
Directly. That's no.
I have
227. No? This application has been filed. The revision application under Article 227 of the Constitution of India has been filed, challenging the 3724 passed by the Honorable Chief Judicial Magistrate and so. Huh? মানে হচ্ছে বলছি this is a revision application under Article 227 of challenging the order dated 3rd July 2024, etc. Passed in connection with miss case number 376 of 2024 আছে তো? আচ্ছা। Hello. The orders order in কোথায় গেল order? Order, let's check. Hello? Full stop. Land counsel appearing on behalf of the petitioner has submitted that the petitioner is tenant in respect of the secured assets and is not a borrower in these circumstances, necessary protection be given full stop. Correct. Having heard learned counsel appearing on behalf of the petitioner as well as petitioner is acting petitioner as well as having gone through the documents the instant revision application stands submitted. Petitioner is directed to serve notice along with the copy of the revision application upon the opposite party number 225 through speed post with AD and also upon the state opposite party number 1 / there through public prosecutor of this court and to file affidavit of service on the returnable date. Considering all facts and circumstances, the order impugned is required to be stayed for the purpose of disposal of the revision application. Full stop. Accordingly, the impugned order dated 3/7/2024 passed in connection with Miss Case number 76 of 2024. Be stayed for 6 weeks or until further order, whichever is earlier. Let the matter appear before the regular bench after 4 weeks করে দিন 4 weeks মানে কবে হচ্ছে হয়ে যাবে চলো 4 weeks hence 4 weeks hence after vacation 4 weeks hence next part হ্যাঁ এই জাজমেন্ট দুটো দিন এইটা আচ্ছা ঠিক আছে
6 weeks. Stay for 6 weeks. Item 13.
13 same same order means why 3 petitions 3 tenancy 3 tenancy
We are talking about same order, the other thing.
same order passed no 3/7 tenant name of the tenants are others 3 separate tenants so have filed separate report একই হবে same order হবে দেখি 1 মিনিট দেখি একই অর্ডার দেখি আগেরটা দেখি প্রথমটা ফার্স্ট যেটা দিলাম ডিক্টেশন দিলাম এটা দিনালি জাবেরাট এটা দিয়েছি এটা দিয়েছি আচ্ছা সেম অর্ডার করে সেম অর্ডার হ্যাঁ চলুন নেক্সট আর আর 13, 14, 15, 16, 17.
Item 15.
Not today করে দিন সাবির আহমেদ হ্যাঁ 16
Item 16.
not today 17
Item 17.
not today none is appearing not today 19 20 17 16 not today $17 not today just now played for not today no nobody is there 16 not today 15 not today 17 this is 17
Well, there's a gentleman called Rajiv Ghosh. Rajiv Ghosh decided to take loan from me. 17 and 18 can be heard together. Well, your lordship does not see any paper. First, here's it. Rajiv Ghosh decides to take some loan from me for selling cars. Cars in the picture of Rolls Royce. They were selling cars, old cars, they were selling to me. In terms of
Rolls Royce.
Rolls Royce. There are only vintage cars. These are vintage cars. There are about 9 or 10 vintage cars which are available in Calcutta. They are generally with two kinds of people. One is with Devarshi Sadhan Bose, and the other one is.
You are the dealer.
I am not the dealer. I'm buying. I'm a person who has material strength. So I was buying. For that, he took about 1.2 CR from me. When he took the money, he entered into an agreement with. There were some problems with the car for which he was not in a position to deliver the cars to me. So he started slowly paying back. He completed his payment of that 1.2. Thereafter, he took loan again. He again paid back. This is one part of the story. He paid back. The other part of the story is so where the de facto complaint is concerned. The de facto complainant had lent money. KPC Medical College had lent money to Rajiv. Rajiv Ghosh has taken money from KPC and part of the money was paid off to me. Now, what is the problem? The problem is that Rajiv Ghosh, there is a complaint, there is an FIR which is registered against Rajiv Ghosh for taking 15.2 CR by KPC Medical College, which is a justifiable FIR. We are not concerned. We are not named in the FIR. What happens in the meantime is, since a particular portion of the money had come into my account from KPC, what Rajiv Ghosh did was, Rajiv Ghosh said that I will be paying you the money. A portion of the money will come from this college. Please accept the money. We took the money. Then investigation started. It was taken over.
Money was transferred to your account.
Money was transferred.
By whom? By whom?
By Rajiv Ghosh. There were tranches of payment. Few payment. What happened was, few payment came from Rajiv Ghosh straight away. And some money, the last remaining portion, very limited amount, came from KPC Medical College, which Rajiv Ghosh told me that please accept the money from him. I accepted the money because so long as Rajiv Ghosh is paying me, I'm taking the money. All my money that I've given is in white. It's all bank transactions. So when the money was coming back, I had no reason to doubt because everything was coming back in white. And this is in terms of agreement, in terms of mails that he's shooting to me. I accepted the money. Then we are not aware as to what has happened. In the meantime, this is a very small amount of money that came into my account. The total amount of money so far as SAC item number 17 is concerned is about 1.2 CR. What happened was 15 crores was swindled out by Rajiv Ghosh from KPC Medical College. KPC kept on paying. Now, Rajiv Ghosh happens to be a relative of KPC. KPC Medical College is owned by Kaliprashanna Chaudhary. So they were relatives. A certain amount of money went over, 15 crores went over to
Rajiv Ghosh. Detective Department started an investigation. Pursuant to the investigation, since a portion of the money came over to my account, which I'm not no way connected to KPC, I'm no way connected to any other thing. My account was marked as lien. They created a lien, they froze the account. Well, since the amount of about 2.2 CR was frozen, 1.2 from here, from SAF, and item number 80 is about 1 crore also. 1 crore 45 and 1 crore 1 lakh. So total amount of money. So 2 crore 45 lakhs is about an amount of money which is frozen. We agreed to the freezing. We said that since an investigation is on, but I was not sent any notice under 160. Well, suddenly we saw that the money which was frozen in my account got transferred out of my account and went into KPC's account, which we couldn't believe. When we went back, we checked the order sheets of the court. We saw that behind our back, without giving us notice, the amount which was created lien in my account, Malad, the investigating officer gave a report and got that transferred from my account to KPC's account, which is unheard of. Now, this is the order which
money came from KPC.
Well, in short, what has happened is, my lord.
Mr. Chatterjee, please let me finish. Let me finish. It's a case where law and facts are both involved. I do not have a problem with Mr. Chatterjee's client. I do not have a problem. I'm not.
It's KPC.
My lord, it is my money. Rajiv Ghosh, my lord, Rajiv Ghosh defrauded I am KPC, my lord, I am the de facto complainant. Rajiv Ghosh defrauded KPC and my lord took 15.6 crores from my lord KPC. My lord, KPC transferred the entire money, my lord, in several tranches to Rajiv Ghosh, my lord, in the accounts of his personal accounts and his business accounts. He owns a number of auto centers, etc. Now, what they do is, charta de, SAFS charta kunta? Kindly have this chart, my lord. Kindly have this chart. This is a unique thing, my lord, that has happened. Rajiv, I'll give a copy. I'll give a copy.
No, it's not a person. Raj, copy. Let me
kindly see, my lord, what has happened.
I have a.
Arey, ama ekটু bolte dao, dada.
No, you cannot. You cannot interject.
Rajiv Ghosh took money from us. Rajiv Ghosh parked the money with them.
Both sides.
Yes.
I am not going to dispose of this eviction application today.
My lord, kindly.
May I just indicate to your lordship one thing? My lord, your lordship would hear me. No. Just
let us be served with a copy, my lord. My lord can fix a date for hearing.
Before your lordship passes an order, your lordship would hear me. I've not completed my submissions yet. What happened was Rajiv Ghosh, once he parked the money once the money was given to me, it was not a case of parking, it was a case of payment. He paid the money to me. He had taken the money in white from me. He paid me back. This money which he has taken from me was being repaid. All documents, my lord, the issue was when the money went out from my account, it was created as a lien. Thereafter,
there was no occasion to transfer any amount to your account by KPC.
There was.
Absolutely.
There was, because Rajiv Ghosh is instrumental in Mr. Chatterjee, please. We know how things are. May I just conclude and then you submit?
Yes. Okay, please wait.
Over here, Rajiv Ghosh is instrumental in ensuring that I get the payment. I get the full payment. My lord, I have annexed everything. The question is that if, let us for a minute, we say that the money which came into my account partially came from Rajiv Ghosh directly and some of the money came from KPC. If it is doubted, the first thing is to ask me that Mr. Banerjee, you please explain how the money has come into my account. Would your lordship take the money out from my account and give it to him without asking me? My issue is this. It could not have been done behind my back. My prayer before your lordship is very limited over here. I am not saying that ensure that the money comes back and I enjoy the money. No, I am not wanting that. I am saying restore the money to its position, create back the lien. Back the lien, my lord. I have 4 proposals before your lordship. I have 4 proposals before you.
But I have not been served.
Just a minute. I am not supposed to serve you because you did this behind my back. You got this behind my back. You did not serve me when this thing was happening.
No.
No. Please speak from the records, Mr. Chatterjee. And please let me complete. When the lien was created, I was not asked. Very well. At this stage of investigation, you can create the lien. Thereafter, my lord, I have given your lordship a particular order sheet. Have a look at that. This is the report that has been given. Please have a look at the report. Most respectfully, seize this report, my lord. Most respectfully beg to state that this case has been initiated on the basis of the complaint. Devajyoti Bhattacharya, CEO of KPC Medical College Hospital. The brief fact of the case is that the accused persons entered into deep-rooted criminal conspiracy and represented themselves as agents of different companies, government offices to induce the complainant to pay 15.92 CR in different occasions for obtaining all necessary permissions, clearance from appropriate authorities, including KMC, for expanding business of the complainant. Moreover, the accused persons have prepared forged and fabricated documents and used those documents as genuine to gain trust. This is all with regards to Rajiv Ghosh. Now, see,
This is after the impugned order.
This
report, this is after the impugned order.
Complete. This is not after the impugned order. Please have a look at what is happening. During the investigation, Maharaj, see the second paragraph. Maharaj, see the second paragraph of the document that I've given your lordship. This is the report. This is the report for a minute.
After the order.
This cannot be after the order.
This is 24th of September.
See, is the so what has happened?
The order
after this
impugned is
the
19th
transfer.
September.
Please have a look. This is 19. During investigation, it has revealed that amount has been siphoned off from the account of KPC Medical College, account number so and so and so and so of HDFC Bank, to the account of FIR accused person Rajiv Ghosh, amounting to 15.36. And 56 has been directly transferred on account. So seize the amount. 56 lakhs has been directly transferred from the account of KPC to the account of SAP, having account number so and so. During investigation, after scrutiny of all accounts, it is revealed that from the portion of misappropriated funds, amount of rupees 1.45 has been transferred from the account of Rajiv Ghosh, having account number so and so, to Axis Bank, having account number so and so. This said account was marked as lien. He specifies after this, during investigation, 1.1 so and so has been marked lien in respect of another account in SAP, having number so and so, where they said a misappropriated amount was transferred. This is coming from Rajiv Ghosh. During investigation, it is revealed that 75 lakhs has been transferred to another account from the account of accused Rajiv Ghosh, having account number so and so, to the account of Bank of Baroda. The said amount was marked as lien. Everything all right. During investigation, it has been further revealed that the de facto complaint that the accused persons has siphoned off. Now sees this. Hence, in view of the above, the investigating agency has raised no objection to transfer. How could there be transfer without hearing me? My issue is this, that you mark lien, we understand. We understand that you ensure that the money does not get transferred. But how could you direct transfer of this money from my bank account to KPC's bank account without hearing me? This is my money.
It's not.
And same day, order is passed without hearing me. Malad, this is the issue.
Which order? Which order?
Malad, see the order. Page 49. Page 49.
Well, I have not been served,
Sir,
sir, but I don't know.
First, seize the order.
No, it matters.
No, but how? If it mattered, then you would have served me. When you were doing this, you did not.
I'm not the police.
You are not the police. You made an application. You should have served
I'm not
me.
the police.
Correct. So go and tell the police now. Page 49. Kindly see. IO has filed a report. Peruse the IO's report. Considering the report as well as the facts and circumstances of the present case, I am of the opinion there is no legal impediment.
Page 40?
49.
Page 49.
Item number 17, your lordship is hearing, right? Item 17.
Page 49?
Page 49. Malat, item number 17 is staff.
ACGM IC. ACGM in charge, Alipur.
Yes. ACGM in charge.
19/9/2024.
Yes, Malat. 19/9/2024.
When this application was filed, yes. Before the,
Please, Malat.
and the manager is subject
Considering the report.
Sir, please try to make yourself understand. This is the cracks of this revision application. If it is transferred to your account, revision application closed.
Yes.
Malad, my crux is that I do not want the money.
Sir, please.
Yes,
please,
Malad.
please.
Yes.
This application was filed before the court. And
that is the IO's report.
IO's report.
Yes, Malad.
And this application was considered by the CGM passed on direction for transfer of the account from money to this account.
Yes.
If I restore by any order now, today,
yes, Malad.
Today, I can stay this order. It doesn't make any difference.
Yes, Malad.
I can stay this order. It doesn't make any difference as already transferred.
And we have furnished bond. Well, kindly see at the bottom of the order, there is a direction to furnish bond. We have furnished the bond.
I'm just indicating.
And one more thing, my lord.
May I just finish? Malad, I have one prayer. I have one prayer.
They have filed.
Malad, Mr. Chatterjee, please, let me finish. After that, you
Don't try
will never
to
finish.
get an order of disposal of this revision application.
What
for-
My lord, kindly see this.
Malad,
They have filed an application before the magistrate for recalling of this order. They are on one hand moving for recalling before the magistrate, on the other hand, they are moving the High Court, my lord.
I have
It's complete
indicated
forum
that
shopping.
Malad, my learning possibly does not realize that I have made that pleading over here.
Your prayer is, you have already made your prayer. Just to pass an order directing, restore the
No,
money.
Alternatively, my lord, freezes that particular money.
Oh, wow.
If freezes that particular money, so that, my lord, what had happened was, my lord, let my learned friend indicate.
They are, my lord, all companies of Rajiv Ghosh.
They took the money.
Rajiv
and
Ghosh
they have
parks
transferred it out.
proceeds of crime with this company.
The revision
SAF, Atlantis, these are all, my lord.
That, my lord, kindly fixes the matter.
No, sir. No, sir.
Rajiv Ghosh, my lord, parks the proceeds of crime with these companies. That's why these companies approach the court together.
Sir, your interim prayer is stay of operation of impugned order dated 19/9/2024.
Yes,
That will amount to a final order.
My lord, no, it will not amount to final order. I am praying two things, my lord. Your lordship stays the interim order along with
No,
that.
no, my lord, not without hearing
Just
us.
hears me. Stays that interim order, my lord, the order which has been passed. Along with that, I'm making a prayer. The either gives the money back and creates the lien.
Sir, no, sir. No.
And the
Order has
second-
been effective.
Here-
Not at all, sir. Not at all.
Second one,
Not at
my-
all.
second.
I'll pass order. I'll
Well,
pass
here's
order.
my lord.
ভিতরে আমি order দেবো।
Well,
চলো।
just
I'm
hear
just-
me for a minute, my lord.
Yes, sir. Sir,
next
I
one is
understand
that-
you.
No.
Sir, I understand you.
Here's me for a minute, my lord. I am saying that the money which is with him right now, that was my money.
Huh.
This money was taken without my hearing, without giving. That
Sir,
money
according-
should be- that money should be liened out with his account so that he can't spend that money. This much,
Sir, your
just this much.
according to your submission,
Yes.
the
No,
amount
it has not been
It
done.
has been done.
amount pay, KPC entered the amount to your account.
Yes.
The amount.
Only 56.
This is not your money.
It
Yes.
is my money.
No.
Rajiv Ghosh, my lord, first is, my lord,
It's
kindly
KPC's
understand.
money that Rajiv
One is
Ghosh put in their
KPC
company.
paying Rajiv Ghosh paying me. That is one. And the one is KPC paying directly to me.
There was no relation between KPC and you.
Yes.
Correct.
No
But
relation.
it's Rajiv Ghosh, one of their agreements to this effect. Well, it's a disputed question.
What is
It's
it?
a disputed
Yes,
question.
that's
Now,
why.
in
Therefore, the revisional court should not be
investigation-
Actually, revision, if everything will be, everything will be settled, everything will be dropped, rather dispute will be dropped after disposal of the revision application.
No, after conclusion.
My lord, they have.
There's hardly any,
My lord,
Say, I can
interim
say
order.
that my lord would lordship kindly ensure
I can stay.
your lordship stays the order and your lordship does not give the money to me. Does not give the money to me. I am saying let this money, like the way lien was created on my account, let a lien be created on his account and he gives an undertaking that he will not spend this money.
No, sir.
Otherwise, if
No,
it is not decided.
No, sir, no such.
my lord, may I just indicate three things to your lordships?
Yes,
No such
yes.
prayer is there.
My lord,
No such prayer is there.
my lord, Mr. Roy wants to say something.
If I have understood correctly, Mr. Banerjee's money has already gone into Mr. Chatterjee's
Yes,
account.
yes, yes.
Mr. Banerjee has already applied before the learned magistrate for recalling.
Hmm.
Your lordship will kindly dispose of both this application by directing the learned magistrate to dispose of that.
To decide the recalling application.
Mr. Roy, I'll tell you something. I did not wish to come here. I'm telling your lordship, and this is something which is across the bar. I did not wish to come here. I filed it in the lower court. The lower court, despite seeing the urgency, the money to transfer from his account to another account. Let Mr. Chatterjee say this. He gave a date after
My lord,
1 month.
kindly hear me, my
He
lord.
gave a date. The lower
Kindly
court
hear
gave
me,
a
my
date
lord.
after 1 month.
Rajiv Ghosh, my lord, these are all, my lord, front companies of Rajiv Ghosh to park, my lord, proceeds of crime. These are all ways and means of parking proceeds of crime.
Understand who I was.
And my lord,
It's
with
very
deepest respect, my lord,
happened without hearing me.
on one hand, they are moving the magistrate for recalling, and on the other hand, they are moving the vacation bench for setting aside of the order, my lord. Kindly see, my lord, the malafide involved here, my lord. Kindly see, my lord.
My lord, may I just suggest, may I just
And
suggest?
and we have already executed bonds.
My lord, direct- my lord,
They could have come for an expeditious disposal of their application. They have not done that.
Why
They,
should I
they
do
are
that?
pursuing. They are
Immediately from your account.
By the learned magistrate
They are-
at an early date.
they are pursuing the same relief in two forums.
And I indicated
Uh.
this here. My lord, please,
We have already furnished bonds.
transfer the money out from there.
My lord, দেখেছেন?
To bond, so I could have also given a bond. Permit me to give a bond. How will
Arey,
you
it
say
is
I
not
am
your money.
I am not being.
What I understand that you will not permit me to dictate this order in this court. So I am passing order in my chamber. Next,
Next is same.
Next is same.
Eh?
Same.
Same.
Two companies.
Another parking space of Rajiv Ghosh.
May I just tell
Next
you?
is
One,
one is
SAP.
another is Atlantis. Rajiv Ghosh is the common feature, my lord.
All
This is another parking space, my lord.
all that I'm saying is that all
same,
that
same.
all that I'm telling you,
Rajiv Ghosh takes money from KPC, parks in his companies.
Malak, just comes to page 35 once, not
Stop,
this one.
stop for me.
Malak, just takes the first.
Is the petitioner.
Malak does not take the second application, takes the first application one. Takes the first application. comes to page
Atlantis.
35.
Huh.
Either 35 or 36. Kindly comes to page 35 or 36 and sees what is going on. Sees, I do not have an axe to grind against the de facto complainant. We are fully aware as to what has happened to him. We do not stand in the way. We have no problem with KPC. We make it very clear, my lord. Because KPC also stood due. I have also stood due.
No.
Only problem
You
is
are-
that my money.
You are
went
the
out from
vessel.
the system.
You are the vessel where the proceeds of crime is kept.
Okay, sir.
Kindly please page 35.
It's a medical college that has been
Yes,
duped
sir.
of so much of money. And
Why-
they are buying and selling Rolls Royce cars.
19টা কি হলো 19টা
Deeply obliged.
ওইটা ওই দুটো
Buying-
সঙ্গে হবে না
Same.
20.
20 items your lordship will pass in order later on.
Yes, I will pass order, sir. I understand what I understand. It will never allow me to dictate the order in the courtroom. So I will pass order in my chamber today.
But if we-
Yes.
I assure your lordship, none of the parties will argue further. Your lordship can pass on.
এই দুটো ভেতরে দিয়ে দেবে।
My lord, your lordship.
What I understand after hearing you both sides, it is not possible to dictate the order. Why, who is 20?
No, my lord,
Who is
your
20?
lordship-
Sir, I will pass order today, no problem. And it will be uploaded instantly, no problem.
Let's just tell your lordship, when your lordship is going to pass on orders, just takes a.
Sir,
reference
but
from-
I am not disposing the revision applications. It is the duty of the regular bench. Regular bench will decide.
My
the
lord,
revision
may I make one request before your lordship, my lord?
Before your lordship, he makes another request.
No,
regarding his
my
wakalat.
lord, mine is a very technical request, my lord.
I
I'm
just
filing my
wanted
wakalat now.
One page number, your lordship would see that.
Okay, 35.
No, 35. Along with that, your lordship would see page 36 onwards, all my documents are there.
Yes, I have seen.
Your lordship would see my pleadings once before your lordship passes.
Okay,
Please has a look at the pleadings.
but I am not disposing the revision
Lordships,
application.
lordships.
Next part.
My lords.
Chalo.
My lord.
Who is 20, sir? Please come.
My lord, I wanted to, my lord, say Shubho Vijaya to your lordship.
Oh,
my lord.
yes.
Kindly accept my deepest regards.
It's
my
just
lord.
it's a hard
Kindly accept my deepest regards. Deeply.
Chalo.
Deeply.
My lord, your lordship will not take us amiss, my lord. Kindly.
এই ভেতরে দিয়ে দিন এটা। 2 মিনিটের order। 2 মিনিটের order। ওকে, ওগুলো দিয়ে দিন। দিয়ে ঢুকিয়ে দিন। আর হয়তো রিমাকে একটু বলে দেবেন কি মানে স্টে অ্যালার্ট যাবো আমি দুটো ডিকটেশন দিয়ে দিই। হ্যাঁ হ্যাঁ
I was the charge sheet witness number 1
হ্যাঁ
on
চার্জশিট উইটনেস নাম্বার 1।
charge sheet number charge witness number 1
Sure.
on 26 April 2022 my deposition was supposed to be recorded.
Now present.
That is recorded.
What is your name?
My name is Shitanath Shaw. And on 26th of April, the order has been, I challenge the order of 26th of April order.
26th April.
April. My lord, kindly come to the page number 44, my lord. And once.
40? 44.
44. And the certified copy on the back.
44 is what?
44 is the order.
Yeah, I'm on the certificate copy. Yes, please.
On the middle, it is apparent from the evidence on record that Sitanath Shaw and Rina Shaw are the owner of the case premises. And Parveen Jala is the tenant of the top floor of the case construction where the alleged construction has been made.
Are committed offense 401A KMC Act. Okay? Sitanath, Alice construction has been made. Reena Shah, Sitanath Shah are the owner of the case premises, and Parveen Jalan is the tenant of the top floor of the case construction where Alice construction has been made. Huh.
And my lord, now I am referring the page number.
Other materials recorded Parveen Jalan, Sitanath Shah and are also involved in the construction of buildings. This code also finds the Parveen and so together. They are not tried as an accused in this case. Moreover, there is sufficient evidence. 319 Sitanath Shah. What's wrong, sir?
My kind of come to page number 54. One, my deposition. Point number 11, 12. Point number 11 and 12.
In a visitor shop floor test, I found that hall room, washroom, and three.
I made moreover, point number 12.
I made complaint to various authorities regarding opposite act. This original copy of my complaint
Original copy that has been exhibit serial number 1 that has not been annexed. And on this deposition and the cross, and I don't know whether the accused was made in comparison to the case. There is no on such evidence that I am handing gloves with the provincial and the accused person below each other. Certain, sorry. And the court.
You are the landlord of the
I am the landlord.
premises. So in your premises, construction is going on, but you didn't know.
No, I am not residing over there.
So serve notice and come. Next, come.
Order is also of 26th of April.
What's going on? This revision application has been. What is the urgency? What is the urgency, sir?
My lord? In the
This is an application
petition.
under this is an application under no, this revision application has been filed challenging the implemented order dated 26 April 2022. It was April 22 in connection with passed in connection with criminal miscase number 1803 2017, wherein learned municipal magistrate second court Calcutta invoked the provision of section 319 of the CRPC and arrayed the petitioners, arrayed the petitioner as an accused of this case. Petitioners arrays the petitioner, arrays A-double-R-A-Y-S, arrays the petitioners as accused to this case. Full stop. Forever. Learned counsel appearing on behalf of the petitioner has submitted. Petitioners has submitted that he had no knowledge about the alleged construction. And they were not rightly and they were not arrayed as an accused according to the provisions. Full stop. Having heard learned counsel appearing on behalf of the petitioners, as well as having gone through the impugned order and other documents, petitioners are directed to serve notice upon the opposite party number 2 and 3 by opposite party number 2 and 3 through register post 230 along with revision application, there, serve notice along with revision applications. Huh? Hello? As well as upon the stay through the public prosecutor of this court. And to file evidence of service on the returnable debt. Let the matter be placed before the regular bench.
One thing must be recorded out, my lord. In the meantime, we filed one writ petition where the demolition order has been passed. And the KMP has were already demolished the subject premises, my lord.
Already demolished?
Already demolished the
Nothing remained.
Nothing remained,
But
my lord.
why did you come then for this court with revision application? Why did you come?
And
Okay.